The following is a live broadcast of a Lone Star community radio program, recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and facebook.com/irlonestar. For more information on this show, please visit our show page at irlonestar.com/shows. To sponsor or donate to this program, visit our donate page at irlonestar.com/donate, or email us at lscrstudios@gmail.com, or give us a call at 936-666-1084. Lone Star Community Radio production and broadcast is possible by folks like you. So sponsor and donate today.
You are listening to Lone Star Community Radio on 104.5 KCZW and 106.1 KZCC Conroe, and worldwide on the irlonestar.com.
Good afternoon and welcome to the Legal Connection with Tony and Cheryl. Tony Lynn Collins and Cheryl Ellsworth Jahani. We are two Texas licensed attorneys, and we're here every Tuesday from 12 to 1 p.m. talking about legal issues, things that we think that you that are important to you, questions you may have, things like that. We've been, for the last couple of shows, Tony, we've been talking about this COVID-19 and contact tracing and all of that. Today we are going to be discussing defamation. And Tony and I thought that was a good topic because we were talking about...
People are mean.
People are mean. And, people have been defamed in some way or another. Yeah. Almost everybody has been defamed. Now, whether it's actionable or not, meaning whether you can sue them or not,
Sticks
is
and
a
stones
different
may
story.
break my bones, but sometimes it really is harmful. And the part about defamation that's really bad is it's generally intentional.
Right.
And it's to hurt somebody.
Right.
we already know in the Bible, you don't talk about people, you don't gossip, you don't say things like that, just keep it to yourself. But when somebody's actually saying something that's false about you to hurt you, I was just reading something last night where I can't even remember what it was right now, but it was the same thing. It was where somebody was making something up in order to harm somebody. Gosh, it slips my mind.
It was just a blatant lie they were making up?
Yeah. Oh, you know what? I know what it was. It was. It's so dumb. It was in the scriptures. I've been going to mass every single day, and you're going to know this. It was when Naboth would not sell his small vineyard to King Ahab. Mm-hmm. And so he was really mad about it. It was right next to my property. I want it. Sort of like, I won't mention any large developers we've been in a lawsuit with.
Right.
But we want this little piece of property, and you won't sell it. And so Jezebel, we know nobody should ever name their kids Jezebel for this reason because she was so bad.
Or even your dogs.
Yeah, anything. And I guess it was in the land of Jezreel or something. But anyway, so she tells so her husband complains to her, and she's like, don't worry, I got this covered, no problem.
Right.
So she says, okay, guys, she gets with all the elders in the church. She goes, we're going to build up Naboth, and then we're going to say that he said that he was above God, and we're going to say he said some bad things about God and how he was better than him. And then we're going to find... we're going to take him to court, basically, and then you can stone him to death. And that's exactly what happened. She set him up. They said bad things about him. They were lies about how he didn't honor God, when really he was just not selling his property because it was his ancestral property.
Right.
And then he was stoned to death. And then she's like, guess what, honey?
I got your property.
Now.
Yeah.
Well, today's reading it kind of showed what happened. Today's reading, and they have in Catholic masses, they have the Old Testament reading, and then they have the companion New Testament reading. And in that one, Jesus said, turn the other cheek. If they want it, just give it to them. And I was like, this is confusing. You're saying in one scripture that you need to honor your ancestral land, and then the next scripture it's like turn the other cheek and don't fight. Just give them
But
what
he
they
was
want.
talking about if someone slaps you or something like that. He wasn't saying give them your real property.
Yeah, well, that was kind of confusing. But today, it came around and made more sense. In Kings, it was another reading from Kings, it said that God told Elisha that, hey, do you know what King Ahab did? This is a problem. He's a liar. Mm-hmm. And so I want you to go tell him that he's going to be damned for eternity. So Elijah went over there and told him, hey, you've got a problem. God's going to now fire and brimstone. He's going to kill you and all your family, and there won't be any other heirs. You're going to live, like hell for the rest of your life and eternity. So Ahab came around and put on the sackcloth, and
Yeah,
he's like,
he was sorry.
I'm sorry, I didn't. My wife did it. It wasn't me. I didn't mean to take his vineyard. And so he said, okay, no
I
problem.
didn't mean to take his vineyard. It was an
kill him.
accident.
It was an accident. He got stoned to death. But he said, okay, I'm going to, because you've shown mercy and you've shown so much humility, I'm going to let you live, but your sons are going to pay for the rest of eternity. So the bottom line was she told a lie. She defamed him in order to get him stoned to death. That's sort of like what we're talking about today. People
Great
defame
story.
people so that they can hurt them either by their business or their reputation. And I'm going to read a couple of little passages that were in a United States Supreme Court petition that I just filed, and it sort of, because I was just working on this, it goes toward what you're going to tell us about the law today. And one is, a good name is rather to be chosen than great riches and loving favor rather than silver and gold. And that's Proverbs 22:1. So your good name is more important than riches, silver, and gold. Your reputation is more important than anything that's material. And it says it in Proverbs, and of course the Bible's got truth.
And Tony, isn't that true even practicing law, that our reputations with other attorneys, if other attorneys know us as people who misrepresent facts, who misrepresent the law, our reputation is lost
Even
like
because
that.
it's so important that you're telling the truth to the court.
Right.
And when someone is smearing what you're saying, it's not only insulting, but it's harmful to you. And we already know that the reason that I even had the Supreme Court case was because, that we've talked about it. We had since it's my own case, I can disclose everything.
Sure.
We had a tenant that was mad because he didn't pay his rent. And so we sued him for non-payment of rent, and we won about $300,000 judgment. And he didn't want to pay it, so he declared bankruptcy, and he wasn't bankrupt. And so we knew where the property was that he had. So he wrote, so we sued him for fraud in bankruptcy court, which you can do. All is not lost if somebody has a judgment and then they file bankruptcy not to pay you. So we sued him for fraud in bankruptcy court, so that judgment wouldn't go away because that was wrong. He had the money. And you should pay your debts. I mean, that's in the Bible. That's the truth. It's just money. There was no hard feelings. We just wanted our money. And so he wrote the bankruptcy trustee that I was a drug addict and a cocaine addict.
Oh, yeah.
And that,
I remember that.
Yeah, and I don't even know what it looks
What
like.
a
Being a
joke.
criminal defense attorney, I should know, and I know what it looks like, but I've never touched it. I've never been really even close to it, so I don't know. And that doesn't matter. That he lied, and we're going to go over this today in our show. That was a per se defamation. I don't have to prove any injury because he tried to hurt my professional reputation by going to a colleague that did not know me, a trustee, basically a judge for this particular bankruptcy, to tell them that I was a drug addict to lower my reputation so he would not believe me if I told him what this guy owned. The truth of the matter is, it didn't matter whether I said it or not. I mean, he owned it, and this bankruptcy trustee was going to find out that he had this property. But he defamed me for the purpose of enriching himself and to hurt me. And so that was why I'd written this brief. And we're going to get into this a little bit more later, but more importantly about the law itself. God says that your reputation is very important, and it is. It's more important than silver and gold and riches to keep your reputation. And not only God says that, but our first president, George Washington, said, a reputation once broken may possibly be repaired, but the world will always keep their eyes on the spot where the crack was. So once somebody's tainted you, they're always going to be thinking twice, maybe it was true. Maybe it was true. And George Washington knew, and he had all these great, Benjamin Franklin had all these great things that they say. So even he was saying, your reputation is more important than anything, our first president. Then we have another really important person in I guess, Mad Money, and we do a lot of stocks and stuff. Warren Buffett said, it takes 20 years to build a reputation and 5 minutes to ruin it. 5 minutes. Somebody can just say something bad about you, and now they've tainted your good reputation. Even if it's wrong, trying to get your reputation back. And that's why we have defamation suits, because you need to defend your honor. And then finally, being defamed, we entreat. We are made as the filth of the world, and are the offspring of all things unto this day. And basically that's in 1 Corinthians. St. Paul is saying that being defamed is people saying bad things about you, and then they make you the filth of the world, and you have to defend yourself. How do you defend yourself? You can't just let it go. But That's what we're going to talk about today on should you let it go? And how do you deal with it when someone defames you and you know it's a lie? Do you need to just let bygones be bygones and say, I'm not going to worry about it, or what? So let's talk about that.
Okay, so generally defamation is defined as the invasion of a person's interest in her or his reputation and good name. Modern defamation law is a mixture of common law rules. The First Amendment, which protects free speech and freedom of the press, requires the states to provide certain minimum protections when defamatory speech involves a matter of public concern. So if it's a matter of public concern, that's kind of an exception, as you and I both
Which is
know.
really bad because the politicians and their lobbyists and people that are running for office are the ones that are setting this law that makes it, it's called the anti-SLAPP law, which is the opposite of defamation is your right to sue somebody when they defame you. Say when we're going to get into what all that takes to make a suit. And then Texas has passed something called the Citizens Participation Act, which is and it's also it stands for something, and we'll get into that a little bit later. But it's called an anti-SLAPP suit.
Right.
Basically, if someone defames you because of the way the politicians have put the law together now since 2011 in Texas, if it's a matter of public concern, and that's very broad, they can get away with defaming you. But it was really sad because politicians were mudslinging during politics, and they didn't want it to happen. So they're like, wait a minute, you can't sue me for defamation because that's my opinion. And so they made it so that it was if you filed a suit against a politician, but it could be anything that's a matter of public concern, doctors, lawyers, whatever, if it was a matter of public concern, the courts will dismiss the case and make you, the person that's injured, pay the attorney's fees of the party that you sued for defaming you. All because the politicians didn't want to get hurt when they mudslung.
Yeah. So a matter of public concern, I mean, that's an exception. And it's things like you mentioned, doctors, lawyers. I think that, this lawyer didn't handle my case properly, so I can say whatever I want to about him because it's a matter of public concern.
It may be your opinion, and maybe you can, and maybe it is a matter of public concern. But it's even gone further than that. And to the extent that I've even got this letter here today, we have a letter that was written by an attorney saying he had a client. This client did not exist, saying my client feels like there have been an inappropriate conduct with this doctor. No client existed. He just wrote a letter to another surgeon and publicized it to the community of doctors and physicians to get this particular doctor in trouble because they were angry in this lawsuit that this particular doctor was winning. So this large developer, and I don't mind saying that it was D.R. Horton, had their attorney write a letter saying, my client, it wasn't even D.R. Horton. This attorney represented D.R. Horton, and he said, oh, I've got a different client, and this client feels like you're a bad person. And they got away with it. They got away with writing pure, unadulterated, pure defamation to get someone in trouble, and got away with it because of the anti-SLAPP suit. So we're going to go over when you can file and when you're injured and when things are bad and how the courts sort of align themselves with it because of this law.
Okay, well, so there are elements. Any cause of action has elements, right? So the elements of defamation are, number one, the defendant published a statement of fact. So statement of fact, not opinion.
Right.
Statement of fact, like what does that look like? On this date.
A statement of fact. Well, we'll use just an example. This is a letter from, let me see, who is it from? It was from Carl Dawson, who's an attorney. And we're just going to use this as an example. Okay. Did he make a statement of fact?
A statement of fact.
He wrote a letter to a surgeon, and he has asserted that he has a patient who was recently a subject of inappropriate conduct by an anesthesiologist. Okay? So is that a statement of fact? It could be if he represented a patient who was recently subject to inappropriate conduct. So what's the next prong?
The next prong is the statement referred to the plaintiff.
Okay, and in this particular case, it specifically referred to a plaintiff, a doctor that he was trying to get in trouble.
The third element is the statement was defamatory.
Okay, and if you're saying that a doctor has recently subjected a patient to inappropriate conduct, that's pretty bad.
Yeah.
That's very bad. And what's the last prong?
Well, there are two more, or three more actually. The fourth one is the statement was false.
Okay, and in this case, the statement was completely false.
He didn't
because
even have a
this
client.
attorney did not have a client. There was never any evidence before the court that there was a client, and there was never any inappropriate conduct that was ever put before the court. It was just something that he made up. Okay.
Okay, the fifth element is with regard to the truth of the statement, the defendant was one of these three things: acting with actual malice, negligent, or liable without regard to fault. That's
Okay.
strict liability.
Now say that one more time.
So, with regard to the truth of the statement, here we've already established the statement was false. But
Okay.
let's say if it was true.
Okay.
Was the defendant acting with actual malice, negligent, or liable without regard to fault?
Okay,
Strict
so that would be
liability.
if it was a false statement. Did he say it maliciously, or did he say it because it was negligent because he thought it was true? He heard it from somebody, like
Right.
gossip in your neighborhood,
Right.
Or was he doing it with what was the third one?
Liable without regard to fault.
He didn't care if it was true or false. He was going to say it anyway because he knew it would hurt him. Okay, so those are the three things. Those are the three standards that you have to prove if you don't have per se defamation, something that would injure your reputation. So go on. So we'll keep using this as an example, and our listeners can
and then
apply
the
it.
last one is plaintiff suffered pecuniary injury unless injury is presumed. So there are fact patterns where the injury is just presumed in that, but
And we're
without
going to go
that,
over those, but that means that, for an example here, let's say that this particular doctor was fired
Yeah.
and couldn't get another job because of this false statement.
Right.
Then he's got a provable injury. You have to get an actuary for that kind of thing. It's an accountant that can go back and figure out what your worth was based on your education and what you could have made and and then they can figure it all out. But you have to get an actuary, an expert to go forward. Otherwise, you may not even have a case if you can't prove your injury. And monetary damages are really difficult to prove.
Right.
Okay. Even if you
and
lost
that's
your
pecuniary.
job. Yes.
Pecuniary means monetary, means
Right.
money.
Okay. So, but you don't have to prove pecuniary damage if it's a per se statement. So keep on going. What is the next prongs in the law?
That's it. Those are the prongs. And
Okay,
then we
go to
talk
per
about
se then. What is a per se injury? Do you have that in front of you? If not, I can kind of give you a ballpark of what that would cover.
Well, I've got here that the legal issues for the court to decide. You know, it's hairy. Legal issues for the court to decide. Legal issues for the jury to decide.
If you have a per se injury where you don't have to prove damages, they're the type of injuries where there's like four of them, and one is you've said somebody's a drug addict, or you've said you've done something to taint them so badly that you don't have to even prove damages. It's per se damage. So you've said that, like, a priest, for an example, is sexually assaulting children. You know that's not true. There's no proof of it. You're saying that because maybe you're an atheist and you're mad at the priest, right? That would be per se, something that hurts the reputation with that regard. I'm trying to think of another one that comes up.
Is it they're being accused of some incurable sexually transmitted disease?
Yes.
It's all of those things.
And I'm looking at the defamation law. Let me see what the actual per se is on that. Here's per quad. I think it's just about, okay, here's per se. Depending on the form in which the statement or communication is delivered, defamation per se may also be referred to as libel per se or slander per se. Now, libel and slander are different because libel is to the eye. It's what you read. It's something that's posted online. It's something that's in the paper. It's something that's written to somebody. Whereas slander is something that you hear. And it's a little bit harder to prove unless you've got a recording. But those are the two different types of defamation. Texas defines defamation per se as words that are so obviously harmful to the person aggrieved that no proof of their injurious effect is necessary to make it actionable. So you don't have to prove the actual monetary damage. And that's in this case that they cite is Alanese v. Hoyt. It's a Corpus Christi case in 2003, and that's been upheld by the Texas Supreme Court. There are four types. Statements imputing the plaintiff committed a crime. So if I say something bad about, if I say, Cheryl robbed a bank, but she's still an attorney. I can't believe she's still an attorney, but she's a bank robber. And that's not true, and I can't prove it. Let's say it is true, but I can't prove it. It's not actionable. That's going to be per se because it injures your reputation, and you could be disbarred by being a felon, right? The next one is the plaintiff possesses a loathsome disease. So I don't know what that would be these days. I can't even think of something that you might have, but usually it's what happens with venereal diseases, and you see it when people make the mistake of getting in a hairy divorce, and then they get deposed, and they ask them about it, and they don't talk about it, but they accuse them, and they can't defend it. So they
Like
can't
Michael Douglas and Catherine Zeta-Jones.
Right. You've got he gave me a venereal disease, and then that transcript ends up in the public record because anybody can look it up. That's the reason why you don't want to get a lawsuit with your angry, almost ex-spouse, because they're going to be disclosing things that can't be defended very easily, and it's going to end up in the press. But with Catherine Zeta-Jones and Michael Douglas, they were public figures, and so anything they say is going to come out against them. Because it's just juicy gossip, and the tabloids make a lot of money. Another one is if you have plaintiffs, if you injure the plaintiff's office, business, or profession.
Occupation.
Occupation. If you're trying to hurt them, like a doctor or a lawyer or an accountant, and you've said they're a terrible accountant, they don't know what they're doing. That doctor has killed several people. He has no idea how to do heart surgery. That's per se. Okay, you don't have to prove damages. So in the example we were giving with Carl Dawson's letter, he was trying to injure him per se because he put in a public record. He wrote something which was libel because it's to the eye. He actually sent a certified letter. So that's all it takes is to one person for defamation, right? And he was trying to enter a business profession. And then the last one is statements imputing the plaintiff was engaged in sexual misconduct. And all of these are in Downing v. Barnes, 348 Southwest 3rd, 415 in the 14th Court of Appeals. But these are well-known per se types of injuries where you don't have to prove a damage. So you don't need to hire an actuary or a CPA. If they say something that hurts any of these, you've got defamation.
It's just so obvious on its face. This is interesting. It says under the sexual misconduct, a statement that imputes sexual misconduct is considered libel per se. And in Marshall v. Mahaffey, a financial manager who called a pro golfer's wife a slut was liable for slander per se.
What year was that?
Let's see, that was 1998, and it was in Beaumont.
Okay, we've got a problem. Houston, we have a problem. In 2011, they passed the Citizens Participation Act, which Texas Citizens Participation Act. It's the anti-SLAPP law. That is what I was talking about, which makes it, if it's a matter of public concern, then the person that has defamed you now has got this broad
sheet to hide behind a cloak.
Affirmative defense, even if it doesn't matter if it's defamation or not. And if you sue them because they say, oh, it's a frivolous lawsuit, you weren't hurt by it, whatever. It's a public concern that we know things about that, even if it's not true. Even if it's not true, if it's a public concern, you don't have a chance to even defend yourself. The anti-SLAPP suit says that if you bring this case, the other side that was the bad guy that was making the bad statements can get the attorney's fees from you. And if they hired an expensive attorney, you're stuck with it. And then you have to appeal it and all that stuff. They've changed the laws a little bit throughout the year since 2011. They've modified it and narrowed it a little bit, but not significantly. But we're going to get into that. Let's see.
And then also imputes a crime. A statement that falsely charges a person with the commission of a crime is considered libel per se. And I just think it's interesting because it's on its face. You know, you said this already. It's considered per se, libel per se, if it was so obviously hurtful to the plaintiff that no proof of the statement's injurious character is required to make it actionable.
Right. And that's not hard to do because most of the time, we had done most of the time that's the reason that people are defaming somebody. It's usually not just, they're usually, gossip's one thing. And if you say, and I hate to say this, but if you say, in my opinion, you've now taken it right out of the defamation category. And we're going to get over those affirmative defenses because they're very, very important. The way somebody defames you is almost as important as the defamation itself. Because if they say it's just an opinion, then now it's just that person's opinion, and you're going to read over what all those affirmative defenses. And affirmative defense is when someone says, yeah, I did it, I agree, guilty as charged, but I had a legal excuse. And a good example of an affirmative defense is self-defense in murder. Yes, I killed them. Killing a third party is murder, so to speak, and it's not even so to speak, it is. But you have an affirmative defense in criminal law if it was by self-defense, okay?
Right.
So the same thing applies to defamation. If somebody says something that's completely defamatory in every way, but they say it under the guidelines or under the law that that's come down the pike, I guess, and I'm not really saying this in a very eloquent way, that if they said something that was completely wrong, but they said it with an affirmative defense, then it's forgiven, and you don't have an actionable case. And I'm going to give you the example of my own case, the one I went to the Supreme Court with. The example of of our tenant who we got the $300,000 judgment against for not paying their rent.
Right.
And then they filed a bankruptcy, and then made defamatory statements against me, and I had no dog in the fight other than it was my husband's building that he didn't pay rent to for a number of years. He wrote this defamatory statement to a bankruptcy trustee, someone I'd never met, someone that questioned my integrity at that point, someone that I could be hurt by. He's a federal employee in the same position as the judge would be. Well, we took this all the way to the United States Supreme Court. When we went to the 410th District Court here in Montgomery County, Judge Robbins said, no, you don't have a case because it was in a judicial setting. And you can say whatever you want in a judicial setting. And my response was, no, I was not a party to the case. It was not my money. The judgment was not against me. You can't go around slandering the wives of the people that you're angry with. That'd be like somebody slandering you because they were mad at your husband. Mm-hmm. You can't be telling a judge in my profession that I'm a bad person, I'm a drug addict. They've never met me. That hurts my profession.
Right.
And so she ruled on summary judgment, which my position on that is the Constitution does not say that a judge, one person, can tell you that you don't get your day in court, right, because we don't think the law's on your side. So, and summary judgment just basically says there's no facts that support this will ever win with a jury. This is a matter of law, not defamation. You lose because this guy defamed you to a trustee, even though you had nothing to do with the case. So I took it to the appellate court, and they just summarily said, nah, we don't think so. We think this is a judicial setting, and he can say whatever he wants about you, that you're a bad person, and to whoever he wants, as long as there was a case going on. Well, that's not what the law is. The law says it has to be relevant to the case.
And it was a total lie too.
Yeah, it was a total lie, and it had to be related to the case.
Right.
So you're a drug addict, and the reason that I didn't pay my bills was because you're a drug addict. That's what he tried to say. He said, because you, the wife of my landlord, are a drug addict, well, I didn't have to pay my rent, and so you're a bad person, and that doesn't make any sense. Well, I could have been a drug addict, and that was not an excuse for him not paying his rent,
right?
Even
though you're not,
right. It was, their names were, Michelle and Bill Zollner. They were tenants. I don't know where they're at now, but basically Michelle didn't say it. Her husband Bill Zollner said it, and did it intentionally to hurt me. But on the other hand, I knew it was such a lie, and people that know me know I'm not a drug addict. I'm as far from that, from anything possible. I've never touched that.
Right.
So I was kind of like, well, he's lying about it. But on the other hand, is this really actionable? Is it something I want to do, which we're going to go into? What is it? What is defamation, and how do you deal with it? Was there actual harm? To the extent that there was harm, that this trustee now thought I was a bad person, the trustee called me and he said, have you ever seen this letter? He brought it to my attention.
Really?
And once he met me, he knew that I wasn't a drug addict.
Right.
And I was given the opportunity to redeem myself to him. Mm-hmm. But I thought, you know what? Who else has he told this to? Yeah. So I went ahead and I sued just to see, how the law was in Texas. And apparently in Texas, the Texas Supreme Court said, nah, we're not going to do it. They didn't disagree. The Texas Supreme Court just said we're going to deny your petition for review. We don't have to deal with, we have a bigger fish to fry than your tenant being mad at you and saying you're a drug addict, right? And so I took it to the United States Supreme Court. The United States Supreme Court just last week denied cert. That means that they didn't want to take the case either. So where it stands right now is like 5 circuits in the United States all say, oh no, you cannot defame somebody against their profession. I would have won in, say, California, or I would have won in Alabama. I would have won at a different circuit. But in Texas, because we're the Fifth Circuit says, you know what? We don't care. If this is the Wild West, I guess. If he wants to call you a drug addict and he wanted to defame you, we don't care. And so I because it didn't cost me that much as an attorney, I just took it all the way to the United States Supreme Court. So know this, listeners, if somebody in a judicial setting wants to call you out and completely lie about you, then they may get away with it. But it may not be in my situation. My situation, I met the person that defamed me. And he didn't stop there. This guy, Mr. Zollner, didn't stop there defaming me. He also defamed me to Judge Robbins. He wrote her a letter outside of the court, without making it disclosed to me that I was a drug addict and I was terrible. So he was doing it all over the place to win his case. Ultimately, it didn't change the fact that in bankruptcy court, we ultimately were able to prove that he lied, that he is a bad guy, that he was falsifying records and lying to the court. So the bottom line is, what kind of like with the Naboth case, ultimately justice will be done. But you should defend yourself. I'm glad that I did.
Right.
I would have felt bad if I hadn't tried. But you have to weigh, do you have the cost and the energy? It's really difficult being in a lawsuit. Okay, so what are our affirmative defenses for defamation?
Well, we have limitations.
We know one. What I was talked about was judicial, a ironclad judicial defense, affirmative defense in Texas for defamation is judicial setting, judicial proceeding. So you can say whatever you want about somebody, as bad as that sounds. I'm not advocating that. But if you say something bad about somebody in court, it's supposed to be only in the court setting because you don't know if it's a lie or not. You're just, you're
just giving your testimony or whatever.
You've sued somebody because they stole from you. Oh, I didn't steal from you. I won that case and I was proven to be innocent. No, not by reasonable doubt. And so we don't want people not to say the truth in a judicial setting. We want them to be open. We don't want them to be afraid.
They're going to be sued.
And so there's a it was done wrong in my setting because it was done specifically for the reason to injure me, but he still got away with it. But in the true sense, the reason they have that, and you're going to talk about that a little bit, is that is a judicial privilege, is what it's called. So what are some other privileges that allow you to defame somebody and basically get away with it?
Well, statute of limitations. In other words, the time frame for you to sue me has expired.
Okay, and how long is that?
I don't know, but I do know that in Texas we've got a 90-day rule. And I know you know this too. We've got a 90-day rule is that as soon as the plaintiff learns or has reason to know that they've been defamed, they have to contact the defendant within 90 days or the potential defendant within 90 days in order to give them the opportunity to
retract it.
Mitigate.
They retract it to the same person or same people. And as bad as that sounds, because it really doesn't cure the injury, they've got to mitigate it. So know that if you're defamed, you have 90 days to go forward. Otherwise, the defamation
the cause
sticks.
of action dies.
I do know that defamation is 1 year. It's really quick. It's one of the shortest ones. If somebody defames you and you find out about it 2 years later, you may be able to use the that rule where you're just learning about it. I forgot what it's called.
It's the tolling.
It's the tolling rule where.
Where it tolls until you.
But basically, if you just found out about it, then you can argue that because I just learned of the defamation, I now. It's like people that have a memory. I was raped by my dad, or whatever, which I wasn't, but that's what they scream. I was raped by somebody because they're mad at them. And so they come up, 20 years later and say, I was like.
There's no statute of limitations on that one.
Yeah, because you're just now, the memory is coming back. But, and it's not a murder and rape because that's a criminal issue. But for defamation, it's kind of hard to say that I'm just becoming knowledge. So it's better if someone defames you that you immediately address the issue. You've got 1 year to do it. That means that you've got to file your suit within 365 days of the last time the defamation occurred. So if it's reoccurring, let's say they posted something on their Facebook and they just posted it again yesterday, you've got a full year for that one defamation. Okay, but and it's not when they're served; it's when you file the suit. So that's how it rolls.
Okay, and another one is plaintiff's fault. The defendant can assert that the plaintiff's own acts or omissions caused or contributed to the plaintiff's injury. If the defendant pleads and proves the plaintiff's fault, the defendant is entitled to a jury submission on the issue of proportionate responsibility.
And do you have an
That's
example with that? Usually they give you something like that. My first thought is the example would be if you're in a spitting match, let's say, and you took the information that they told you, let's say it was a recording during a fight, and you published it. It was told to one person, and now you've made it worse. You didn't mitigate it; you made it worse. You published it like, look what this person said about me, how horrible they are.
Oh, right.
I think that's what they're saying, but I'm not sure. So, what is the example?
Well, there is no example, but yeah, I think that's true. I mean, I know it is
you're at
true.
fault, you've got contributory
if I
negligence
heard
'cause-
somebody say something about me, and I came to you and I said, "Do you know what so and so said about me?" I'm the one spreading it. You know. So if you hear someone or you become aware that someone has
This
said
happens
something.
in HOAs. There's so many cases where in homeowners associations, somebody will be mad about something. You know how that goes, and they spread the same thing on and on. And it's different if they've written something and you're saying, "Look what they wrote about me. This is terrible." You're not.
And you're the one spreading it.
Yeah, but the thing is that if they said it and they won't take it back, and you gave them the opportunity, then you're spreading it, but at the same time, you're saying, "What do I do?" You might be so that's a really slippery slope to go on.
It sure is.
But on the other hand, if you have started it, and I'm thinking if someone said something to you like in a fight, and then you spread it like you recorded it, you're creating the problem to get to them, and that's not right. So that's why they've made that law.
Right. And then another defense is truth. If it's true, it used to be, that used to not be an element of defamation, but now it is.
That is an absolute defense if it's true. And the problem, you're going to have to prove it's true. And as attorneys, we say things all the time that are the truth, particularly in our pleadings. But of course, we have a judicial privilege too. But if you say something that's true, for an example, I have a client that's in a lawsuit with a developer, and they've lots of clients do. You have some clients that have done this too. They put a billboard up. And they are mad. They are furious, and they want people to know that these people are bad because of what they've done to them. And they'll put a billboard up. Well, the billboard's fine. I mean, it's kind of expensive. I don't know why you'd want to do that. I mean, you've got bigger fish to fry. But if it's to help the public, the billboard's a really very important thing to do. It's a way to notify people in your community that something bad is going on and be watching out for this person. It's the best way to do it. And the truth is a defense, and so go ahead and do it. But you got to be really careful because you see that restaurants do this a lot, where they'll post something on a sign out in front of their restaurant saying, I don't know. I think there was a restaurant way back in the day, Ruggles, that had posted something out in front of their restaurant that said they were talking bad about somebody, but it was true.
Ruggles was like a
Ruggles,
patron or something?
Yeah. It was about they were mad about their landlord or something. Gosh, I can't remember what it was, but they were like, "These people are really bad. Don't work with them." But it was the truth, and it was bad. I can't remember what it was now, but it was really bad, and it might have been about a competitor. It was something that I thought, I can't believe they can do that, but it was the truth. If it's the truth, you can say it, and you can publicize it, and you can put it on a billboard if it's the truth. And it may very well be helping somebody. So if you had a doctor, and I'm not saying that you want to do this, but if a doctor didn't do, let's say we did have a case like this, but they didn't publish a billboard where this person's stomach was, it was malpractice. He snipped both arteries or veins or whatever to the stomach, and they killed their stomach, and the person ultimately, after a while, died. If they wanted to put a billboard up that said, "This doctor did this to me," it would be the truth, and you'd be maybe doing somebody a favor because they may not know that this person was maybe an alcoholic and operating on you at the same time. But you'd have to know that first. Another way to get around that is if you said, "In my opinion," which is what we're going to talk about a little bit. But I think, and this is really important, why would you want to do that? And this is, of course, my opinion. Why would you want to go that far when you've got things you could be helping people? If somebody, it's like what Jesus said, turn the other cheek. A lot of times, sometimes you want to look at, kind of weigh what you're doing and what the result's going to be on your own life because we only have one to live. Do you want to fight with people all the time about bad things they say about you? Yeah. It may not be worth your while. So you really have to look at whether it's going to help other people saying this, or what they did was that bad, or if to really go forward with it, or to just sort of let it go because people are never going to believe it anyway, or they may already know. But what's another privilege?
Consent. The defendant can assert the defense of consent. Consent is a complete defense to a defamation action. For example, a contractor who voluntarily entered a bidding process for a construction job implicitly consented to the possibility of a negative assessment by the bid committee. So he got a negative assessment. He was angry. He's saying, "You're defaming me," but the law says you consented.
That happens a lot with doctors. Doctors go into, they have, I was reading a case where this heart surgeon, and it was all bad too. It was another defamation case. He had a pristine record, and he was working at one of the big hospitals in the medical center. And then he went to go work for a different one. So they were mad, and so they let only part of his peer review be published. But it was the part where they had said bad things about him because they were mad. And then I think ultimately the new place he worked didn't hire him, or they let him go or something because of that. So he sued, and he won a lot of money.
Really?
So he didn't sign anything. I mean, but he kind of consented because as a doctor, you're going to get a peer review. But he didn't ask for that. He didn't ask for them to be angry that he went to go work for a competitor because they were going to pay him better or whatever the case was that he did. And he won a ton of money.
Good
so
for him.
Consent is another sort of slippery slope. You can consent, but you may not have consented to that.
Yeah. Okay. Another defense is libel proof. The defendant can assert the defense that the plaintiff was libel proof. A plaintiff is libel proof when she has no reputation to lose.
Yes. And we can think, we have to go all the way back, Jezebel, we're going back to the Bible. Where, and that, unfortunately, is a lot of what we do in criminal defense.
That's so true,
We
Tony.
try to make them, but the reason we're in criminal defense is we've got some gal that's falsely accusing somebody. All my aggravated sexual assaults, my sexual assaults that aren't dealing with children, they're adults, it's always some estranged wife or angry girlfriend who's been dumped, or angry wife who's got a cheating husband, or angry girlfriend because he won't leave the wife for her. They assert sexual assault. I didn't say they could do this, but they're tramps. They're having sex with everybody. I mean, this is their reputation. And so our job, it's a bad job.
Unfortunately,
is to see what they told the police and go unravel it, but it's basically, if they lie once, they've lied a million times, and it's pretty easy to defend these cases. So guys, if you've been falsely accused, or if it really did happen because it was consensual, don't let this be the end all. If we can, as criminal defense attorneys, prove that the person is lying, and it's not hard because these people lie about everything because they try to bolster their story. And this goes with all criminal defense. If somebody's falsely accusing you of doing something, robbery or whatever,
true.
you gave them something. Oh, she robbed it. Look, she's got it in her possession. When you actually bought this, you go prove the person that's making the accusation is a liar, and it's not difficult. So you want to make sure your attorney is subpoenaing the records, looking at everything they said. Where do they work? Were they on drugs? You look at what you basically ruin the person that's saying it's reputation. But you're not doing it publicly. You're doing it to the prosecution. So it's kind of confidential. It's kind of sad. It should be public. But if the person that's being defamed, and we're going to flip this back over, if they are the person that's supposed to be injured, if you're calling them a streetwalker, a prostitute, and they are a prostitute, well, it's true. And that's particularly
they were libel proof.
The case if you're calling them a prostitute and they're reformed and they're good and they're going to church and they're not doing it anymore, but they've got a conviction for prostitution. There's nothing you can do about that.
Yeah.
It's going to stay with you for life. So don't be prostituting.
And then we have different kinds of privileges: absolute privilege, executive privilege.
Okay, what's the executive privilege?
High-ranking state officials have an absolute privilege to publish defamatory material in the performance of their official duties.
Okay, so the president can do that.
Yeah.
Executive.
You've got legislative privilege and absolute privilege.
When you're before, and that is why a lot of what was going on with the accusations against Trump by Nancy Pelosi and who was the other guy that
Chuck Schumer.
Adam Schiff, Chuck Schumer. They were saying it during legislative settings, and so they can pretty much say whatever they want, and it's really bad if it's being publicized. And if it's not true, then poor President Trump or poor person that they've come out against. And the same thing happened with Justice Kavanaugh. They can say whatever they want.
Unbelievable.
Yeah, unbelievable. And
Unbelievable.
there doesn't have to meet the burden that you would have to prove in court. They just can say what they want, and it's really, really sad. But that's the legislative privilege. What other privileges can they have?
A judicial privilege,
That was the one
we talked about.
And it's very broad. It's not just in court under oath. This guy was writing to somebody about me, and I had nothing to do with the case, saying I was terrible and I was a drug addict and all these things, which I could prove they were not true. I had to actually go get a drug test to prove I've never had any, nothing. I've never taken any drugs. I don't even take vitamins.
Right.
And I had to prove that, but it looked bad because here I am going to court proving that I'm not a drug addict.
I know. Totally.
And so it's expensive. But anyway, so yeah, that's another privilege is the judicial privilege.
And then we have qualified privilege.
Now, what are those? Those are important because they're not absolute.
Yeah. The defendant can assert the defense that the defamatory statement was protected by qualified privilege. Qualified privileges arise out of the occasion upon which the false statement is published. This privilege is termed qualified or conditional because it can be lost if a person does not use it in a lawful manner or for a lawful purpose. That is, it is lost if the defendant acts with malice.
Okay, right.
So
somebody's saying something nasty about you. Let's just use the homeowners association example. Somebody says, that guy is a thief. He can't pay his mortgage. I think it's because he does drugs. And but he's mad because his next door neighbor his son stole his car, and maybe he thinks it's there may be some qualified privilege in there. Because in that situation, he was a hothead and he didn't mean it. And there may be something in there where, for that particular situation, this is a terrible example. I know there's other ones. For that particular situation, it may have been opinion. There may have been something to get around it, but it was just in a moment of anxiety that maybe he didn't mean it. Maybe he didn't know. Maybe there wasn't but there wasn't malice. It was just it was malice for the moment. But that's a terrible example, and I may not be right on that. So
it seems to me that if he didn't know and all of those things that you were saying are true, but he had actual malice, then that undoes the qualified privilege.
Yes,
right? And so then we've got common law qualified privilege. We've got when the statement is made without actual malice. To be protected by common law qualified privilege, the statement must be made without actual malice. So like in your example, and the guy that he's making the defamatory statements about didn't steal his son's car. There was no malice. He just really thought the guy was on drugs. One time he saw him and he was staggering around or whatever.
Yeah, or maybe it's another example is you thought you saw somebody stealing somebody's car. So it wasn't actual malice. You're just reporting something that you saw.
Right.
And it's defamatory. And I'll give one other example that just kind of came to mind about that, and that was when, I'm losing my mind because I just thought about that. All right, let's go on to another one until I remember what I was going to say.
If the statement was communicated, now we're talking about defenses still, the statement was communicated to another person with corresponding interest. To be protected by common law qualified privilege, the statement must be communicated to a person who has a corresponding interest or duty. For example, complaints made to the police department about police officers' behavior were communicated to an entity with corresponding interest in investigating behavior. The privilege is lost if the statement is communicated to a person who does not have an interest in the matter, and the statement relates an interest in the matter.
That was why my case should have gone forward, because the statements were completely unrelated in any way to rent payment. They were just statements to defame me, so that my reputation would go down, so this thief's reputation would go up, right? But if it was related, I thought I think, and it happens in court cases a lot too, and I remembered what I was going to say. It was, there was a case where a reporter, it happens a lot with reporting.
Right.
A reporter had written about a suicide, and she didn't name names, but I guess he eventually had come out. And so the family of this person had sued, and she said, hey, this was a matter of public concern. I thought, but it really, how's a suicide a matter of public concern? And we just had that case yesterday where they found the unfortunate guy that was in right off of Ella near the Home Depot off 610 in Houston, where they found this guy at 9 a.m. and he hung himself.
Oh, gosh.
And they didn't disclose his name, but they ruled it to be a suicide. And they don't disclose names during suicide because there's no public interest in somebody's mental health issues and something they're sad about. But if it was a homicide, you're going to hear all about that, like all the stuff going on with Brooks and with George, Floyd and all that junk. So, but this reporter was exonerated under a qualified privilege because she said, hey, if I used his name, it was an innocent thing, and I was just doing the report. But she won under that. So
okay, well, good. All right, well, we're getting the signal that we're out of time.
Well, how many minutes do we have left? 2 minutes. Okay. I want to say this real quick, and it's kind of important. Posting explicit images online for revenge.
This is good.
In this modern digital age, it is often common for romantic partners, particularly those in long-distance relationships, to exchange revealing photos of one another. These photos are often intended for the eyes of the receiver only, but how can you be sure? What happens if you break up or the other person turns out to be less discreet than you had hoped? Is it illegal for someone to share those photos with others? Unfortunately, in most states, the answer is no, it is not illegal. Indeed, posting explicit photos of someone is legal in every state but California and New Jersey. So you can do it in Texas.
Wow.
This has led to a small but growing industry of websites specialized in such unauthorized photographs and videos, often for the purposes of allowing an angry or jilted ex to humiliate their former partner for revenge. Often the content is even tied to the person's full name, social media pages, home address, phone number, and other personal information. I forgot what that's called when they out you that way. Some of these sites even run a form of legal extortion by which one can buy reputation protection services to pay them not to put on there. It's really, really bad, and we want to go over there from the next show. But be careful about photos because it's a form of defamation. And if you send a picture of yourself scantily clad, or if you pay someone to do it for your lover or whatever, and they get it, and then they get mad later, the photographer gets mad later, and you've given them some rights to it,
Right.
they can post those, and it's really difficult to undo that. Unless, of course, you've got a gorgeous body and you don't mind. If you're 80 and you look really hot, and it's okay.
If you're Suzanne Summers, right? Man, she looks good. Okay, guys, we are here every Tuesday from 12 to 1 p.m. You can listen to us on 104.5 or 106.1 FM, and you can watch us live on Facebook, too. We're available to download the podcast tomorrow on Google Play and iTunes, and we thank you for listening, and we want to remind you
To serve God by serving others.
have a great week.
Today's show was recorded and broadcasted live on irlonestar.com, Conroe's FM 104.5, 106.1, and all rights and ownership are reserved to Lone Star Community Radio. For more information regarding this program and Lone Star Community Radio, visit us online at irlonestar.com. Lone Star Community Radio is Montgomery County's community radio station, serving the community with local programming on TV, radio, and online. If you enjoyed today's program, please support us by sponsorship or starting your own show. Contact us today by phone or text at 936-666-1084 or email the station at lscrstudios@gmail.com.